Everybody, welcome in. Oh, I think today's gonna be, yikes. We might need a divine intervention. Ken, where you at? We need help. Cause today's gonna suck, man. It's just gonna suck. All right. But hopefully it won't suck that bad. We'll see, no guarantees. Oh, goodness gracious. All right, well, welcome in, everybody. Welcome in. I'm kind of doing a little pop-up here. We've just got so much stuff going on. It's hard to just keep it all in one spot. So, hello, Kimber. Hello. I'm still getting myself sorted, so just a minute. Trying to figure out, this is a hard part, everybody. Which ring do I want to wear today? That's how my life is right now. Which ring? That means you're doing good. You're doing well. If that's all you need, then you're good. All right, hold on here just a second. Hello, Anita. Hello. Goodness gracious. Which ring am I going to wear? How did this become so difficult to decide, huh? All right. So I've got, we could do that one. Maybe we could do, no, we're not going to do that one. Hello, Ken. Oh, I was just saying we needed some divine intervention, and then here you are. Hello, Willie B. You know, Ken, I thought I'd ask yesterday if you could talk to your boss about the snow situation. I see that you have not. Hello, yes, excellent coffee time, for sure. Oh my goodness gracious. All right, I'm picking out my rings right now, everyone, so just uno momento here. Oh my goodness, it's gonna be one of those days, everybody. It just is. Just feel it. It's coming. I am just getting started. Yes. Hello, Katie. Hello, Boxer Mom, too. I am just getting started. And it's going to be a bit of a mess because, yeah. Listen, I don't know what happened, but my regular setup here is a light. Oh, thanks. It's a light, right, a ring light, and then also a, whatever that holds the phone. But apparently I was too aggressive. Good morning. I was too aggressive and I broke the light off of the arm. So let me see if I can just show you a little bit here. I'm embarrassed, so that's why I have to show it to you, okay? I don't know if it'll work here, but here. Here's my other light. Hold on, everybody. We're going around the room. Here's my other light, and here is where it broke off of. So that's not great. So we're MacGyvering it today with an old, oh my gosh, tripod situation. So, and those who have been here with me when I accidentally punched my computer, it's the similar situation, only I was awake. All right, we got a shadow here. Here we go. Let's bump it up. Anyway, bear with me, everybody. Hello, Tiffany. Hello. Yes, one of those manic Mondays. Hello, Katie. Hello, Farron. Good to see you. So we'll just keep on trucking, right? We'll keep going forward. So if you need me to move the angle, please feel free to let me know. All right? Oh, goodness gracious. Well, there's a lot going on today. Hello, Virgo. Hello, Christina. Hello. We've got stuff going on. We've got 2 cases, I believe. Oh, my goodness gracious. This one's going to fall too. No, I can't have my backup one down. I need one. There we go. How are we on that one? Anyway, I do need gifts. I do. Thanks, Erin. Right. So thank you all very much. I do need to replace my tripod ring light situation. So up to you. Oh, good, good, good. Oh, good. Thanks, Big Grandma. I really appreciate that. All right, all right. Let's get into it now that this is a. Oh my goodness! Oh my gosh! Thank you so much. Oh my goodness. What? Oh my gosh. Oh, I love it. I love it. It's so fun because I've got two screens, so I can look over here and be like, "Woo, cool gift," and then I look over here and I'm like, "Woo! Oh my goodness! Look at all of those." Uh, now I need to fix stuff. Oh, Aaron, but it's true. All right, let's dive in. It's been a crazy day. Thank you all for the gifts and thank you all for the support. I appreciate it. All right, everyone. So we've got the Supreme Court in session. We've got two cases, I believe, that they're arguing. Don't forget, I always like to remind everybody about Brino DC. All right, he's another creator here, Brino DC. He does great work. He's actually in DC, and he goes to some of the hearings, right? And he's also hanging out, going through the U.S. Supreme Court, all right? So he's an excellent person. Oh, thanks so much, Craig. And then diving in can be dangerous. True story. True story. Oh my gosh! Thank you again, everybody, for the gifts. I really do truly appreciate that. I'm MacGyvered here in the corner, so nobody touch anything, or it could all fall down. Oh, good, Allison. Good, you did. Oh, we love it. We love it. The other person that I just absolutely adore when it comes to going through Supreme Court cases is I think the name is Skelikos YouTube, maybe. But if you put Skelikos in there, you'll find him. And he's just an incredibly intelligent person and has kind of got his finger on the heartbeat of the U.S. Supreme Court. So I always enjoy hanging out with him when he's listening to the arguments, so we can kind of talk about analysis and talk about different views of things, which, we also do with Brino DC. So both of these creators are amazing. Yes, he is a delight, Big Grandma. I think some of you are following him already. And we've had a really nice, oh, thank you so much, Jen. I appreciate that. I had a hard time choosing. I'm hitting decision fatigue, everybody. But anyway, yeah, he is June Marie. He's great. He is just a great person to sit down and talk with. He's got lots of different perspectives. So Brino DC and Skelikos, the two big creators that I'd recommend for Supreme Court stuff. And then of course we have the SCOTUS blog as well that's out here. So with that, let's just I'm going to update you real quick on the Supreme Court situation and then diving into a few cases. So this is going to be a little bit of a mishmash. But I think we're okay for that. Yes, they're both great and informative. Exactly. And their formats are different. And that's what's so fun for me is to get the great legal analysis from two different perspectives. So here we go. We have the, okay, who's been hearing about a Burgerfell? Let's get a show of hands. The mishmash. Thank you, Navy Vet. Just Skelikos. Excellent. Thank you. Mishmash is, the name of the game today because it's a Monday. So has anyone been worried about a Burgerfell? A Burgerfell. Okay, let's clear it up then. Let's hear it up. Clear it up right out of the gate here. So I had read a few months ago, and I'm sure many of you had joined me on this. A few months ago, there was a lawsuit filed by Miss Davis. Now, she filed this lawsuit because she was part of the Burgerfell situation. She had been sworn in. She was county or state. I think it was county. She's a county worker, and you had to go to her in order to get married. And she's like, I'm not going to give you your paperwork. So she was part of the Burgerfell situation. And Burgerfell, of course, is the same-sex marriage situation. So she was part of that. Now, because she was part of that, she owes a heck of a lot of money. She owes, she's got some big debts, and it's not just from attorney's fees, but she's got a lot of stuff going on. So county, thank you, Navy Vet. Oh, I appreciate it so much. Hello, James. Hello. Yes. Oh my gosh, Navy vet. I'm always so glad when you've got my back in here. I really do appreciate it. So she filed recently in order to get some kind of immunity for being a government worker. That's not how that works. So her case was super weak. We did go through it, and as we were going through it, I was like, man, this isn't really Supreme Court esque. But at the very end of her filing was a sentence where she said, and we asked the court to overturn a Obergefell because it was decided wrong. So it was like just a couple of sentences, right? So she had filed this, and then the rumor was a Obergefell was going to be overturned, which is not at all what could have happened, because not only did she have an insufficient case truly, but the way that she pled the Obergefell question was not appropriate either. So we had some problems with that. And so today, hi Mimi, today we have denials of cert. And that means, to give you some idea here of what we're dealing with, that means that her, let me find it. Where'd she go? I should have marked it, but I didn't. I was too busy working on my MacGyver setup in here with my lights. She has been denied. So the Supreme Court has said, we're not going to listen to your, oh, here it is. Nope, that's not right. It's Davidson, but first name's not Alonzo. But we're not going to hear your case. So that was denied today. So with that, again, let me see if I can find her in here. There are a lot of cases, everybody, that the court is refusing to hear. And I mean, they get so many cases in front of them on cert. So writ of certiorari is how you get your case in front of the Supreme Court. It basically means like, hey, I've got a big issue here going on. Off to college. Oh my gosh, so fun. Oh, Chris, have a great time. Love to see a picture if you've got time and energy. But yay, off to college. All right, she's in here somewhere. Was it this one? Nope, that's Davey. Well, whatever. She's in here somewhere. I think it's Kathy. Yeah, I'm just not seeing it. Well, that was the anticlimactic. So I'll refer you over to Legal Dad. Legal Dad has done a post on the situation as well. And he actually has pulled out where her name is on the list. So that's what, thanks, Sophia. So that's what I would recommend. She is in here, but they've denied it. And they don't explain why they deny stuff. They just deny it. So that's kind of where we're at here. She had a weak case. We went through it. And then, of course, the others just weren't pled properly. Let me see here. Let me make sure. Yeah, we've got O'Brien here. So, again, that kind of got away from me. But I'm still looking here. What else we have? So looking again at all of these are all cases that they're saying we're not going to take. All right. So she's basically, they're saying like, we're not going to listen to your case. They've got limited access anyway, or limited time for that. Hold on here a second. We've got a bot in the chat, everybody. No, we need him blocked. Let's see. Yeah, Kim Davis. Where are we at here? Let me see here what I can do. In my MacGyvered situation. MacGyver. Are any of my mods here? Are you guys here at all? Let me see. I'm really struggling here with this today. Yeah, hold on. Oh, no, yeah, no worries. Yeah, this account's kind of a weird situation going on here. Weird. All right, I got her. I got it blocked. Sorry, that was like an extra step. You're too cheeky. You're too cheeky for a bot today. All right. Come on for a minute. No, I'm good, Ferrum. Oh, but thanks for the offer. I appreciate that. Nope. I was making sure I could go grab her too. So got it. Yay, we did it. We worked together to get the cheekies away. So, Ladora, I'm doing a quick SCOTUS overview. Too cheeky. Too many cheeks. And then I'm going to dive into reading some other things. But this is just kind of a showing everybody where our cases are at here. So we did have, yes, Kim Davis. I forgot who told me, but thank you, chat, for that. Appreciate it. Yeah, so it was tossed out. So whatever the lower court said, which was it should be dismissed, is what the ruling's going to be. And she had gone up district court and appellate court, and they had all dismissed, and then she tried the Supreme Court. So next, we've got rehearings that were denied. So they basically said, we want you to double check this. And they're like, no, we're not going to do that. Then we have attorney discipline, which I think is important. Quick, sticky. Yeah, let's do that. I think it's important to remember that, we do go after attorneys who are behaving badly. So, all right, let me see here. SCOTUS, a list for today, which is the 10th. All right, I'm slow walking everything because, I'm having one of those days. Oh, yeah, very good news. Thank you, Navy vet. All right, 25-125, Kim Davis, right, against David Arnold. Exactly. Oh, sure. All right. So, and there's squirrels everywhere this morning. Beware of the squirrels. So here are the attorney disciplines. We've got in the matter of George Girton of North Haven, Connecticut, suspended from the practice of law in this court, and a rule will issue returnable within 40 days, requiring him to show cause why he should not be disbarred from the practice of law in this court. So that's not good when that happens. So we've got some discipline action going. They're giving him a chance to kind of correct the problem or to give some explanation. But if he doesn't, he could be fully barred, and that's relatively rare. Hello, Upgrade. Hello. Love to see you. Good morning. All right, so that's number one here. And then next, in the matter of discipline of Scott Eric Diamond. And this one out of Philadelphia, Pennsylvania, suspended from the practice of law in this court, and a rule will issue. Again, returnable within 40 days, and he needs to show cause why not only he was suspended, but that he could be disbarred. So, hello, Krista. Who's that? I don't know who it is. These are just some random attorneys that are in the troubles here. I mean, random to me. Other people are like, that's my attorney, and blah, blah, blah. Here's the next one. Joseph Michael Owens. Ooh, I do know an Owens. I'm not sure he's in Maryland, though. Baltimore, Maryland, suspended from the practice of law. So he's in the same situation where he needs to show the court why he should not be fully disbarred. So 3 attorneys got into some trouble. If you do want to look the details up here are their case numbers. So all of this is open to the public too. None of this is private information whatsoever. So it's available. Sometimes when decisions get made and one of the justices gets, all worked up about it, they will add a dissenting opinion or a concurring opinion if it's that important. For Justice Sotomayor, she's always like, I got stuff to say. We love that. But this one is, there was a case here in front of the Supreme Court on the petition for writ of certiorari, which I believe was denied. And Gorsuch wasn't very happy about that. So he wrote in here like, I'm not so sure about that business. So, yes, thought all attorneys knew each other. Well, we don't. And there's been a big difference too between attorneys right now. We're going through kind of like a great divide. And, anyone that's been in, I don't know, it might just be unique to law school, but in law school, we have so many friends. It's like boot camp, only not physically, just boot camp for your brain. And what usually happens is we'll have this small group of like slimy jerks and jerkasses where they are, typically generational wealth is involved, and they go in and they're like, I own this place. Like that little girl that was like, get me a squirrel in Charlie and the Chocolate Factory, right? Or actually any of those kids. They're Charlie and the Chocolate Factory kid attitude. Those are there, and that's about 30%. So what's happening is that we're actually splitting again, but rather it just be in our law school class, it's in the legal profession, where we're just like, whoa, you are out of line, and I'm not going to give you a squirrel. You know what I mean? Verk assault. KK Curve. You know what I'm saying, Andrea. You know what I'm saying. So we're on the precipice here. We can try to get them out. Elitism impacts attorneys too. Oh my goodness, yes. Oh my goodness. And the elitism, if you don't take care of that, you're gonna get it everywhere. So, you got to nip that in the bud pretty quick. All right, next up is just this code section. And I'm just sharing this as a screenshot for anyone because so many people are worried about a Obergefell. They're worried that it's going to be overturned. And what I try to remind everybody is that a Obergefell was about a federal statute. So this is which one is this one? Defense of Marriage Act, right? So this is DOMA. This was passed, I think, under Clinton, where they kind of set out definitions. And within those definitions, it basically said you could not be, they said, they said marriage could only be between one man and one woman as husband and wife in the federal statute. All right. So this is what got overturned by a Obergefell. So they say, I'm going to shorten it. I don't think he would mind. But here is where the Supreme Court was like, no, that's not constitutional. And then over time, over a few years, the rest of the DOMA statute was overruled. And what they did, stop worrying about people. Well, and as long as it's legal, I mean, I have to step in for 1 second and give my legal spiel, which, by the way, there are some great articles explaining the two different statutes. But here's the second statute that was passed, and this is the Respect for Marriage Act. So, Respect for Marriage Act. It doesn't quite roll off the tongue as much, but hello, Tracy Bean, welcome. Yes. So Congress came in basically, and once DOMA was kicked out of the way, put the language in to protect a Obergefell. All right. The reason I say that is because if you're just asking a Supreme Court to overturn a Obergefell, the case, especially without any grounds for it, they would be overturning congressional law. And that's like something they don't particularly enjoy doing. Here's my one little caveat, everybody. And I think it's important to note, I know a lot of people have this love is love, right? Love is love and leave it alone, which I get. But also, anytime I hear that, I think about the criminal cases that I have where someone wasn't reciprocally loving, you know what I mean? So it's like love is love, true, but certain kinds of love is illegal. So, and you know what I mean, right? If they're not old enough to consent to love, or if they're forced into the love, or if the love is malicious as a way to manipulate, then the love is love doesn't work. So love is love so long as it doesn't violate the law, is how I put that. All right, so don't get me wrong, I'm, full speed ahead, but just with that one caveat, and some people will come in and be like, well, love is love, and try to use that as a defense. No. You still have to follow the law. Just like if you want to burn a cross, sure, go for it, but you cannot do it on somebody else's property, so if you want to do something wrong like that, as long as it's consensual, yes, and legal, yes. I think that's great. I think that's absolutely great because sometimes consent is not enough. So I get out into the weeds here. There you go, Kel, between two consenting adults. It doesn't have the same ring, though, to it, does it? Like in my house, we have several things that say love is love, and wonderfully so. But it wouldn't have the same ring to it if it was like, well, consensual to legal adults or 3 or 4, whatever. But it needs to be consensual. Like that doesn't, make a square in a blanket very good. So I understand. Yes. Human adults, right? So the love is catchy, and I love what it means. So I think that's great. So I just put the little asterisk underneath it. There you go, T. That's what I'm saying. Exactly. Terms and conditions. Be respectful. Is true. Age. Well, I don't think actually we have an age here. Let me look real quick. I didn't think they included an age because it's so different from state to state. So this is federally recognized marriage right here. So they've repealed the Defense of Marriage Act here, right, between one man and one woman. So that's been repealed. Full faith and credit, certain acts, records, proceedings here. So really what they had is a definition of who can get married rather than a set of, oh, let me just read this real quick. It's only three pieces. So we've got Congress finds the following. Number one, no union is more profound than marriage, for it embodies the highest ideals of love, fidelity. I think Mr. Orange didn't read this. Devotion, sacrifice, and family. 2, diverse beliefs about the role of gender in marriage are held by reasonable and sincere people based on decent and honorable religious or philosophical premises. Oh, that's a good way to put that. Therefore, Congress affirms that such people and their diverse beliefs are due proper respect. 3, millions of people, including interracial and same-sex couples, have entered into marriages and have enjoyed the rights and privileges and tax breaks associated with marriage. Couples joining in marriage deserve to have the dignity, stability, and ongoing protection that marriage affords to families and children. Again, that was another big thing in the DOMA law, or the previous law. If a same-sex couple wanted to adopt a child, right, they could be and were and are, to some degree, in my opinion, discriminated against, right? So you got to be careful here. And I think this is an excellent explanation that's wide open enough to cover everybody, but narrow enough to be followed. Deserve dignity, absolutely. Okay, what I gotcha. What bachelor major did you complete to become a lawyer? So I have, of course, a political science. I have a political science for my undergrad, but when I applied and when I went in to do political science, I was not on the journey for law school yet. So I didn't figure out I wanted to go to law school until my junior year in college. But I did major in political science and I minored in rhetoric, which is basically the study of speaking. So that was that. That was how that went down. But then I decided, yeah, I'm going to do law school. We can do it. But there's a mix. It's a mixed bag. I'll tell you that right now. It's a mixed bag. We've got, I would say, 3/4 of the students were in the soft sciences, and then 1/4 of the students were hard sciences or the math area. So that's kind of how the split was. But it just is any lower degree is what you're needed. If it's consensual but harmful, well, I would say if it's consensual but harmful, I would recommend taking a look and seeing how the rules are for hockey. All right. So in hockey, you're going to get hurt. I don't know anything about hockey other than teeth getting broken. Okay. Forgive me, Canadians. I offend again. But, if you're consenting to it and you get hurt, it's like, well, that's one of those situations where you made that choice, right? But I wish I did, Krista. No, I had to pull back for medical reasons. But going back to the hockey situation, the thing is, a regular injury within the course of playing hockey versus, like, if you're playing hockey and, again, I don't know, you lose your teeth, right? That's a lot different than, you get sick because somebody poisoned you, right? I mean, you're like, I didn't consent to be poisoned, but I did, I consented to injury in the normal scope of hockey. All right. Yes, lots of hockey in the U.S. Yeah, my bad again. My bad. I will always struggle with that one. So, yes, if it's legal, consensual between humans, adults, with permission on both sides, fully understanding what's happening. Not be afforded to only men and women. Good point. Good point. Humans, right? So, because that's important. I know people are marrying their dogs, but that's not technically legal. So, because your dogs technically are property. So, I know, don't come for me. Here we go. We've got marriage here. We've got religious liberty here and statutory prohibition. So there we go. That's a quick update on that. That was tossed today. Cert was denied. Here, if you want just kind of a very interesting walk down this road, if you want to learn more about it, the Obergefell v. Hodges case is available. What I would really recommend, though, is if you've got a little time and everybody's like, we don't have time, and I get that. But instead of a podcast, right, sometimes instead of a podcast, I'll come over here, and this is oye.org, and they have included the oral arguments. And the oral arguments for Obergefell, there were a lot of them. I think there were like 5. No, that's not right. Well, okay, the arguments, there were a couple, but then there were sometimes the judges, when they give the orders out, they'll read their piece of it. And so we had like a total of 5 things you could listen to. So if you're interested in that, then you can take a look and listen. One of the things that I think, honestly, for me, that had me starting to question Roberts, the Chief Justice, when I started to say, I'm not sure, Roberts, about what you're doing, is his dissent in this case, because his dissent is he's very mad. He's very mad, and he believes that it was decided incorrectly. And I think the first couple of sentences were like, those of you celebrating this today, I hope you feel good about destroying the sanctity of blah blah blah. So this, in my humble opinion, I feel like this is where John Roberts came in and kind of showed his true colors. So that's available if you want to look into that, if you're interested. Yes, oye.org. Thank you so much. All right. So again, I've just got a couple pieces here, and then we'll move forward. Again, I remind everybody of where the circuits are here. We have 13 circuits, which is weird because we only have 11 numbers. All right, so the 11th circuit down here is the last one that's numbered. So we do have a DC circuit, all right, and then we've got a federal circuit. And the federal circuit's a special circuit, so that's number 13. The DC circuit's where you try to file all your stuff that's happening, like in the Capitol or the president, right? So we have a lot of DC cases. But the federal circuit's like the federal trade court, right, that we were seeing with the tariffs. That's filed in a federal circuit court, the specialized court. Legal partnership, I would say. He can jump off a cliff. Hey, who's spicy today? Willie B. Don't go to the dark side, Willie B. Stay over here. Oh, goodness. All right. So just a basic reminder. 13 circuits. Do we need more? Yeah, we do. Do we need more justices? Yeah, we do. Is it going to happen? That's up to Congress. Congress can make a change and add more circuits and add more justices. Only can be done through Congress. So it'd be great if they would do something, but whatever. Right now, we're just trying to keep the lights on, right? And then a friendly reminder, every case starts at the district court. This is where our trial is. And then if you don't like it, you can appeal. The Court of Appeals, it's all based off of the record. We're not hearing witnesses. We're not going through evidence. We're looking at the record. So this is all just paperwork, digital paperwork in the Court of Appeals, all right? And then if you don't like that, then you're appealing it all the way up to SCOTUS. And SCOTUS then is looking at Mika's briefs, your briefs, their briefs, everybody's briefs, and they're certainly not taking any evidence or witness testimony, all right? Some people kind of get this mixed up, and understandably so. So any of our witnesses, any of the stuff that we need for trial is going to be done in the district court. If you are appealing and we've got issues of law, then we're going to go up here. Issues of facts down here, issues of law up there. What's the record that was in dispute? So we were talking about a Obergefell. So we had the Defense of Marriage Act section. I don't remember. It was like section 3 something, I think. Make sure your briefs are clean. Darn tootin', Bruce Wayne's mother. Darn tootin'. All right? Because that's important. So one more quick looky-loo. I don't know what's happened. I don't know what's happened in my language, everybody. I had just a little bit of sugar on my oatmeal, and I think my body's like, what? It's trying to take over. Oh, my goodness. All right, quick reminder of our Supreme Court. We've got Justice Sotomayor, who was appointed in 2009 by Obama. We have Amy Coney Barrett, who was appointed by Trump in 2020. We have Clarence Thomas, appointed by Bush in 1991. So this dude's old. He's super old. He's the oldest one there, all right? And then we've got Gorsuch on the bench, Trump in 2017, George W. Bush with the Roberts. He's the Chief Justice here, 2005, and then Trump again with Kavanaugh in 2018, and W. Bush, just like Roberts here. They came in at just a year apart, is Justice Alito. Justice Jackson is the newest one to join the bench here, and she was appointed by Biden in 2022, and then Justice Kagan, of course, who was nominated and approved by Obama in 2010. All right, so that's just kind of a brief overlook. If you're looking for ideologies, it's going to be mixed. Justice Sotomayor is the most liberal of all of the justices, and Justice Thomas is the most conservative of all of the justices on the other side. Barrett and, well, it used to be Roberts, are pretty good swing voters, so they swing. Gorsuch and Kavanaugh tend to lean very heavily on the conservative side. Of course, Alito is also conservative. So Thomas, Alito are the most, and then Kavanaugh and Gorsuch. Justice Jackson, also leaning liberal, and Justice Kagan, she's a bit of a mixed bag too. She may go to the conservative side depending on what the issue is. She's she's got a lot of years of knowledge behind her, so she's like a liberal light. So it's not guaranteed every time. So that's a quick overview of the Supreme Court. Why is Roberts the chief if Thomas has been there longer? Right. Great question, Willie B. The thing is, when we lose a chief justice, like we lost Rehnquist, then whoever's president at the time that the chief justice passes or retires, that president chooses the next chief justice. So rather than having it go on seniority, when it comes to the chief justice, it's down to the president. The president actually picks the next one. Roberts worked for Rehnquist and had a pretty huge resume and had been definitely recommended multiple times. So he came in next, hoping to have another little Rehnquist. I do have to say Rehnquist was probably one of my top 3 least favorite judges ever as a chief justice, and Roberts is definitely walking in his footprints there. Oh, sure. All right, just a couple more screenshots for anyone who's interested. We do have several people have asked about this over time. There is a lawsuit on the books, of course, regarding Mr. E, whose name I can't say on TikTok, and Mr. T, this guy. I think I can say Mr. T. All right, so these two fellas were sued, right, for the harm that they did to a particular person. So this lawsuit had several pieces in it. The most important thing are, in my opinion, are the information given by the victim here, right? So she went and explained some of the stuff that had happened with these two fellas when it comes to the criminal issues. So there is a lot of information. People forget that this was filed. It was later, again, this is her sworn statement, it was later dismissed because she ran out of funding and she couldn't keep it going. There is no way in a case this complicated that you could proceed pro se, especially if it's an essay situation. So she just had to drop it. So it wasn't the court was like, no, there's no evidence. No, she had actually she had withdrawn because she couldn't pay for it. Really? Oh my goodness, dang. All right, now here's another one, and this is kind of the one that I might stop on and read a little bit of if we're interested. We've got two roads. I do want to start a Constitution series to refresh everybody on the Constitution because, you know, that's important and people are kind of mixed up on it. But yeah, she was in a bad place. So for safety, she withdrew it. Right. And just because a lawsuit's withdrawn doesn't mean it's not valid. And, you know, just because a lawsuit continues doesn't mean it's valid, which we've learned from Mr. Orange. So it's just, you know, it's a mixed bag, so to speak. All right. So I had several people request this and I chuckle because it's like, what's happening in the world? This case is this is a legal case that was filed on June 10th of 1975, right? So, oh my gosh, yes, it's always good to do. It's always good. This is a publicly available document of the U.S. against Fred T. Rump, Orange T. Rump, and T. Rump's management. So this is kind of a big whoop-de-doo when we've got this out here. So I just wanted to read a couple of paragraphs on here and then leave it to you if you're wishing to go and get the rest of it. All right, so just a few paragraphs. All right, how am I going to do this? I got to make sure I don't use the buzzwords here. Here we go. Okay, here we go. And then this is a criminal case that was filed. Oh, it's a civil action, actually. We've got a consent order here. So lawsuits here. And it was filed in 1975. So we've got a dad and son situation. A lot of people recently, I've noticed here, this is the consent order here. So let's make sure we know. Consent order. So a lot of people, again, have been posting and saying that there was no discrimination element to Mr. Orange. And, you know, a lot of us are saying, well, of course there were, because and there was a lawsuit. So this is the lawsuit. Yes, Abuelita, you got it. Yep. Discrimination, exactly. So there is no doubt, if you look to the legal paperwork, that there was an issue going on. But let me just read here a couple of paragraphs to kind of give you the flavor. And if you feel like you'd like to go out and pull the rest, it's up to you. So here we go. 1975, everybody. Are we ready? No, we're not ever ready. All right. This action was initiated by the United States of America on October 15th of 1973, pursuant to the Fair Housing Act of 1968. Here. The claim of the United States is that the defendants have failed and neglected to exercise their affirmative and non-delegable duty under the Fair Housing Act to assure compliance by their subordinates, with the result that equal housing opportunity has been denied to substantial members numbers of persons, and that defendant's subordinates have failed to carry out their obligations under the Act. Defendants vigorously deny said allegations, like, oh, shocker. Accordingly, without adjudication of the merits and without any admission as to the existence or absence of liability, and in order to resolve this matter without further protracted litigation, the parties hereto are prepared to resolve this case by the entry of a consent decree. All right, so this is their, this is basically their plea deal. All right, when they came out and they're like, meh, all right, we'll take. See what do we need to pay, right? What do we? Oh my gosh, I'm scarred. I'm so scarred from all of the different attempts to add hair when you don't have any hair. Giuliani forever now. All right, here we go. 2 more paragraphs here, just to, again, to give you an idea. It is expressly understood and agreed that the execution of this agreement by Orange Management is in no way an admission by it of a violation or of the prohibition against discrimination as set forth in the Fair Housing Act of 1968 or any other applicable statute, rule, or regulation. Irrespective of the merits of the complaint, however, the principal officers of Defendant Orange Management are prepared to affirmatively assume and carry out the responsibility for assuring that their employees will comply with the act and will promote equal opportunity. Accordingly, the parties are prepared to resolve this case by the entry of the following consent decree. So a couple things here. First of all, making it so clear that they're not admitting to any wrong. Second, saying if there was any wrong, it was their employees, it wasn't them. So that's, that's pretty typical, I think, of this particular world. So it is hereby ordered, adjudged, and decreed that in consideration of their affirmative assumption of responsibility contained in Part 3 herein, the complaint against Fred Orange and Donald Orange is dismissed against them in their personal capacity with prejudice as to all allegations contained therein and predating this order. All right, so we've got a big lawsuit here, everyone. So if you're interested in more of the details here, we've got the injunctive provisions are set out here. This is like 1975. Rich people can get away with whatever. And then there were some changes made here. And then, who wrote that? A newspaper of general, such as the New York Times. My goodness. So there's some written bits and bobs. All right. So there you have it. I want to dive into the Constitution today. So just wanted to make sure, was 29. Yeah. So he'd been doing it for quite a few years. By the time it made it to court, for sure. All right, so here we go. This is what I would really like to, and we've still got some time together. Due process. Yep. Well, I mean, they went through due process because they're in court and they're filing stuff. So absolutely. Seeing those in the paper. Really? Oh, I don't doubt. We should read the money laundering cases on Russians laundering out of his condos. Oh, I've not seen that. I mean, I've seen plenty of Russian cases involving him, but I've not seen that particular one. Interesting. All right, well, let's dive here into the Constitution. You've disliked him since then. First Amendment, yes. But let's go ahead and dive in. So a lot of people are very patriotic about the Constitution, rightfully so. We, this whole country's like, woohoo, yay, for the Constitution. But many of them, outside of the Second Amendment, don't understand it. So I wanted to just take a peek here into the Constitution, walk you through it. This will be multiple parts because it just takes a long time to get through. So I think it's in really 1983. Well, I'm not okay. I'm not surprised. So anyway, let's dive in, everybody. I'm gonna go through line by line and explain and take questions. Also, now we won't make it again. We won't make it through the entire Constitution, but I was like, let's just get started so people understand how Congress works, at least. So, do we need a sticky note for this one, everybody, for the Constitution? Because I am happy to do that, just not sure. Right. Oh, of course, Dana, of course. I love talking about the Constitution. It's my favorite topic. Okay, you got it, Ferrum. All right, so this is the U.S. Constitution. And we're going to just make this kind of a Q&A, everyone, as we go through. So, and then I'll leave the rest open. So here we go, everyone. We the people of the United States. So quick background, of course, as many of you already know, I'm only a Bill. That's funny. Where did Mr. Bill go? Oh, he's in the other room. I must have made a skit for him. Orangeburg. Oh my gosh, that's so funny. Oh my gosh. Orange will never look the same to me. Here we go. So, right, 1776, we've got the Declaration of Independence, right, which is a different document. And Declaration of Independence by Thomas Jefferson sent over. Then the people, though, were like, dude, how are we declaring our independence when we don't have government? So they had to go forward and figure out what to do. So they had a Continental Congress, and then they had the Articles of Confederation, which were rubbish. They tried to arrange it so that everybody was happy, which was not possible because we've got states plus we've got, the federal situation going on. So federalism is what the problem was with the Articles of Confederation. Some of the most important pieces to remember about the Articles of Confederation. And by the way, I have done a full series on these if you go and look at my playlist, as well as the Constitution. But the problem was, of course, that Congress didn't have enough power, so people just wouldn't show up. It was one of those things, if anyone's been in a work situation where somebody has to be like the chair of the meeting or whatever, and nobody wants it, so the shortest straw is the one that gets it. That's what Congress was like under the Articles of Confederation. Nobody wanted to be there. Nobody wanted to do it. They didn't care. They had really high levels of people voting yes or no in order to get anything done, and they didn't like it. So it was a problem. And, John Hancock, by the way, whom is one of my favorite founding fathers. All right, he is my favorite. So you might get a couple of little insights here with John Hancock. But he was like hanging out in this Congress and was like trying to make it work. And everyone's like, nope. It was completely on a voluntary basis for the states to give any tax money or to give any money to Congress. So they didn't have any money. The federal government had no money just coming out and in of the Revolutionary War. So no money was there. That didn't work. And nobody was showing up. So they're like, forget about it. The reason that's important, we've got strict dates of how you can close Congress and open it back up because nobody was showing up. And so that was like a really big whoop-de-doo-dah. Now, the Articles of Confederation, after a period of time, they said this isn't working, called another convention. And in that convention, they realized that they couldn't fix what was broken in the Articles of Confederation. They had to start a new document. And that's why they sat down. Well, I don't know if they sat down or not. They were mostly intoxicated, so I'm going to assume they sat down. But they sat down and said, what are we going to do? So James Madison, of course, we refer to as the father of the Constitution. Here's James Madison. Thanks for coming today, James. Appreciate that. The father of the Constitution, because he wrote most of it. Now, between him, though, even though he wrote it, the big debate on trying to figure out how everything worked was really through the Federalist Papers here, which were Alexander Hamilton, James Madison, and John Jay. John Jay was like the best lawyer ever at the time, and was the first Chief Justice on the Supreme Court. Really liked. He was very well liked. He was very intelligent, did a heck of a lot of work. He's kind of one of those forgotten founding fathers. So these three did it. Mostly it was Hamilton and Madison because they were big blabbers. And then John Jay's like, I actually got stuff to do. And then, lest we forget, we have the Anti-Federalist Papers. So these are the arguments against having a federal government and just letting each state basically be its own little country. And this was Patrick Henry, who again is known for incredible orations, speeches that he would give at different places talking about freedom, blah, 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 and then multiple other people. But Patrick Henry really did the lion's share of the Anti-Federalist Papers. All right, so there we go. Side quest, quick side quest. So at that point, after the Federalist Papers, boom, we've got a constitution now. The Bill of Rights was requested by a lot of states. And they're like, dude, this is really important to us, especially freedom of speech. That's why it was the First Amendment. And religion. That's also why it's the First Amendment from the Iroquois. So, right. So I have to write this down so I don't forget. I still need to tell you about the Bill of Rights. All right. So oh my gosh. Let me tell you quick about a side quest involving the Iroquois. Benjamin Franklin, all right, yes, that guy. He really, really appreciated the Iroquois, or the indigenous people in the U.S., like not just the Iroquois, but a lot. So Benjamin Franklin, basically 20 years earlier than any of this, had put together the Articles of Confederation that he thought would be really good, and based it off of how different tribes kind of work together. Now, I use the word tribes because that's what the language is in the history books. So when we're talking about the format by the Iroquois, I'm saying their name wrong too. They had a really cool thing going, right? Because they had all these separate tribes of different, nations, of different nations, but they still, they all lived here. So they're like, we gotta, work together. So they are the ones in the beginning that had set out this kind of confederation, and that's what it was called. Basically their governments, their laws that they had, because each different nation had its own set of rules. But then there were rules that went to certain parts of the country. So absolutely, Benjamin Franklin was like, dude, they know what they're doing. Sat down, wrote a whole bunch of them out, put together a little government here, and was like, this stuff is amazing. Now, I can't forget the other fellow that was involved, but because there's another fellow, I think he was like the mayor of, the governor of, I don't remember, but there's another dude who was assigned to actually writing the Articles of Confederation. So Benjamin Franklin's like, here you go, dude. And the dude was like, sweet, let's talk to Congress. And then they talked to Congress, and Congress was like, no, we don't want that. And I mean, it's the convention fellas, all right? It wasn't technically Congress. So they looked at it and they're like, no, we don't want that. So tossed it away into the cupboard and did not ever come back to it. But after 1776, when they sent that letter out, then that dude, whose name I forgot, was like, holy crap, we don't have a government, rush. And then was like, okay, what was Benjamin Franklin doing? Let's kind of make a, cheaper, dirtier version of that and see what we can do. And then, oops, puzzle, everybody. Wish me luck. Puzzle piece. Tea break, yes, I know. I get so excited, though, about the history of it. I got to watch myself. All right. John Dickinson. Yes, thank you so much. I appreciate that. Dickinson, yes. Well, and I feel so bad for him, too, because he knew that Benjamin Franklin's articles were amazing, and they would have worked great. But, the other people were like, we're all drunk and stoned and we don't like it. So those articles, again, collected dust. New articles were written. They were rubbish. And then eventually they had to come back and fix everything that was wrong. And the Constitution, was born, or whatever. Oh, born's not the right word right now in this current political environment. But Right. So the states were like, dude, we'll sign, we'll ratify, but we need a Bill of Rights because the Bill of Rights was so important to them. Each one of the Bill of Rights, because, they're fighting against the monarchy, right? Oh, T, thanks. Thank you. I forget sometimes. So Madison wrote the Bill of Rights in New York, which were actually originally 12 articles. So the Bill of Rights, and then brought them in front of the other people. And they're like, okay, this is good enough. 10 of those were accepted. So there's the Bill of Rights, all right? 2 different times. The articles were written, 7 articles, designed the government. Later, Madison was like, dude, let me work on the Bill of Rights, and then worked on them in New York, and then boom, they came in and were added. Whew, thank you. Well, the Declaration of Independence separated us from the monarchy. It did. But on the other hand, if they could not find a way to work together, to have a government together, there would be no way for the states to actually fight against the crown, right? Because they're all just individual states, none separately with enough power. But if you put them all together into one United States, then together with 13 of them, there's enough power to fight the crown in order to have that independence. It was absolutely was a breakup letter. So here we go with this. Right. Declaration of Independence. So what was I saying? Hold on. Oh, right. I did do the Bill of Rights. So I'm going to check that off my list. All right, so here we are. It's the Constitution. We added to it over time. We have books of Federalist Papers, but let's get into the language, okay? Oh, of course. Here we go. We, the people of the United States. Now, here's the preamble, and this is something that I think is very, very important, but also not a law you could use to argue anything, all right? A lot of times, even the Supreme Court will quote pieces out of the preamble, and other courts will do that also, but you can't come in and say, well, according to the preamble we should win because the statute is for establishing justice, and that's not going to work. So this is not a legal source that can be used. Now, the language in the rest of the Constitution, every single word's important. Absolutely. And, bring it to court, we'll work it out. But the preamble is special to that. It's not to be used technically as a piece of law to rely on. And one more thing before I start diving in again. I just can't stop talking about the Constitution. I just love it. But we also have a preamble to the Bill of Rights. Did you know that? Probably not. But we do. We have a little tiny, little mini preamble when the Bill of Rights was put forward. All right, so here we go. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Now, I remind you that this isn't something you can build a legal argument and say, well, according to the preamble, I should win my case. Right now in our courts where we've got, I think we're at about 450 lawsuits that have been filed against the administration at this point. And that's just how many have been filed. Where they're at in the process, that's a different number. But some of them are saying that the president has extra power because he's providing for the common defense, coming here into this preamble and using these words in this language to justify him having more power than the other 2 branches of government. So just remember this. It's beautiful. It's very well written. And of course, it's kind of like that, let's get her done, charge forward situation, but alas, cannot be used to win your arguments. Well, hello, Crimson. Yes. All right, presidential immunity. Right, that comes later. Is BS. Well, yeah, I think I went too far, but that's a different live. We'll get into that. All right, so 7 articles. The first article establishes Congress. So both the legislature based off of population, and then the Senate where everyone gets two. And that, of course, we call that the Great Compromise between that. Much appreciated. Oh, of course. Hello, Linda. Welcome in. Welcome. High notes, sing the... Really? I didn't know that, Taylorina. Oh my gosh, how fun is that? I'm going to have to look a little further into that. Okay. 7 articles, design the government. Got it? So the Great Compromise meant population and 2 for the Senate. That way there was this kind of equality piece that they wanted, because the 13 colonies, some were bigger than others, right? Like Rhode Island was, don't blink or you'll miss it. So, but Rhode Island was like, we're not going to sign this Constitution because we're so small, but we want power and we're powerful. That's a story for a different day. Article 1, so many squirrels. Yes, I mean, it's right. It's little. There's nothing wrong with being little. Here we go. Article 1, Section 1. So when we're reading through the Constitution, I'm sure everybody knows this already, but just make sure we're all on the same page. 7 articles, so the articles start it, and then we've got a subsection. Article 1's the biggest, so it has the most subsections. And then within the sections, there are clauses. So that's how we cite the Constitution. So if I wanted something here regarding the year that members are chosen for the House of Representatives, I would cite it as U.S. Constitution, Article 1, Section 2, Clause 1. So that's how the citations work on here. Article 1, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. All right. So all legislative powers. Before I move on from that, what are legislative powers? What's another way of describing these powers? So legislative powers, because it seems like it's the process of, let me make sure this is up so you can see the comments. Creating laws, right. Is that all legislative powers would be making the laws, lawmaker, exactly. Yep, that's exactly right. And the reason I bring this up is because we must remember, all legislative powers, so making law, is left to Congress. The president does not have legislative power. The president cannot make law. Now, he can shift policy around through executive orders and move some things here and there, especially if we're in a time of war. He can kind of, dink around with stuff. But when it comes to laws, he does not make law. And if he tries, then he gets sued. And if he keeps trying, then he gets sued 450 times. Because only Congress can make the laws, all right? So just remember that. You get questions like, well, for me, the birthright citizenship piece, right? He's trying to say birthright citizenship needs to be out. We have federal laws that put birthright citizenship, codified it outside of just the courts. So we have a lawsuit precedent, and then we also have a federal statute. And so he's coming in and he's saying that not only is the Supreme Court wrong on a 100-year-old precedent, but the federal statute that also gives birthright citizenship needs to be revoked. And again, all the legislative powers are in Congress. So it's not just easy to say to the Supreme Court, I need you to overturn your own decision, right? But it's not as easy to say, pull this piece of federal law out, because they're very careful about that. Right, World's Strongest Mayo, Mr. Mayo. Yes, side note, Mr. Mayo down here in the comments is putting together a very nice series explaining the Constitution in 2 minutes, unlike me. Highly recommend a follow, everyone. So, legislative powers here, let's go into Section 2. Section 2, the House of Representatives shall be composed of members chosen every second year. All right, so that's every other year. By the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. So this electors piece is kind of janked around because of the 12th Amendment, because the Electoral College didn't work that great. The elector and Electoral College stuff is actually in Article 2 here. So we'll skip on through this. Clause 2, no person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. So that's it for the rules. Those are the requirements, age and location. Next, Clause 3, representatives and direct taxes shall be apportioned among the several states which may be included within this union. So again, this apportionment piece is like who's going to pay, who's going to be taxed, how much are they going to be taxed, and what's going on. Now, of course, the 16th Amendment set out income tax, clarified that situation, but this was written before that amendment was added. So at this point in time, this was the only guidance they really had. Now, as we go through this, also there are certain words and phrases that are no longer legal, but, we're not scratching them out. They're just part of our history. So if we don't like something in the articles, we pass an amendment to change it. All right. And, that's how you amend it. You can't get rid of it. Once it's written, it's written. All right, here we go. And that's very important to note here, right? Respective numbers, which shall be, all right, appointed here, several states, which may be included within the union, comma, according to their respective numbers, which shall be determined by adding to the whole number of free persons. Now, this language, free persons, is used constantly in this era, of course, because of slavery. Now, free persons is used, but also free men is used quite a bit. So, of course, I think you know what that means, including those bound to service for a term of years and excluding Indians not taxed, 3/5 of all other persons. All right, so that's offensive and does no longer works after the 13th and 14th Amendment in the Civil War. All right, yeah. So, and I take a moment to say, some people are like, we don't want to talk about, the slavery because it's awful and it might make people feel bad. Dude, like every country, people do crappy stuff. But, you learn about it so you don't do crappy stuff again. Every country has that, but apparently in the U.S., everything has to be perfect, I guess, and we can't talk about slavery. Like, that makes no sense to me. Any country is going to have problems, right? Because as we learn to do better, then we do better. So lest we forget, if you find something out there where they're like, oh, you're making people feel bad because of slavery, I would remind you to remind them it's in the Constitution, right? We can't just cut it out of history. All right, that's my soapbox. Right, next up, the actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term here of years, in such manner as they shall by law direct. Again, this says here, the meeting of the Congress of the United States and within every subsequent term in a manner as they shall by law direct. So they set out what their timing is going to be for actually going in thank you so much. Going in and setting the timing up. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose
3. So New Hampshire was like, we want an extra one or we're out of here. Massachusetts gets 8. Rhode Island and Providence Plantation 1. Connecticut gets 5. New York gets 6. New Jersey gets 4. Pennsylvania 8. Pennsylvania was a major player in a lot of this. No, that's all right, Gen X. That's all right. I'll be back around. I'll be back around the loop-de-doo. New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, South Carolina. Virginia's got a lot. I don't think it was West Virginia. I think it was Virginia and West Virginia at that time. North Carolina's got 5, South Carolina's got 5, and Georgia's got 3. So they even set it out here. So for the first period of time, who got how many. And it's looking like New Hampshire's like, whatever, they only get 2. All right, next clause. Clause 4, when vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. So let's just say for a minute there's a vacancy. I don't know, we'll just pick Arizona, right? Then who here, the executive authority thereof, should go through and fill that vacancy. So that's actually part of the Constitution here. Philly or New York City, the first capital? It was New York. New York was the first capital, and then it was moved to D.C. All right, and that's clause 4. So clause 5, the House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment. This is where we first hear impeachment on the table. So we're 5 clauses into the Constitution, and they're like impeachment, because it's just that important. Hello, So Unique. Hello, welcome. So very important piece as well, this power of impeachment. Now, if you're impeached, which we have impeached some presidents, it doesn't mean that you're removed from your position. And we have had federal judges who've been impeached and have been found guilty in the Senate and have been removed, but we have not had a president do that yet. So this is the beginning here. Now, let's hit section 3 as well. Next up, so section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof. Now, at the time, the legislature picked the senators, but we did pass the 17th Amendment, which made it a popular vote. So we had to fix that. For 6 years, and each senator shall have 1 vote. Immediately after, they shall be assembled in consequence of the first election. They shall be divided as equally as may of the first election. I skipped the line. Where'd it go? They shall be divided as equal as may be into 3 classes. That means, everyone, every 30% of our Senate is always going to be up for re-election whenever the House is up for re-election. All right. Here, so class shall be vacated at the expiration of the 2nd year of the 2nd class, at the expiration of the 4th year, and the 3rd class, and at expiration of the 6th year, so that 1/3 may be chosen every 2nd year. So 30% of the Senate is on the ballot every time the House of Representatives is on the ballot. Oh, of course, Lisa, of course. Okay, next, and if the vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. Okay, so yes, next year, 30% of our Senate is on the ballot. It's just a matter of trying to figure out which ones. All right, because they kind of all get moved around a lot. All right, hold on here. My pages are out of order. Oh, my goodness gracious. What? How did that happen? All right, section 3 here, section 4. Okay. Let's keep going on section 3. I was like, we're missing a page here. 33, that's right. 33. All right, so we're still here in section 3. So let's finish this one up. Clause 3, no person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. Clause 4, the vice president, this is so important right here, everybody, right here. The vice president of the United States shall be president of the Senate, but shall have no vote unless they be equally divided. So the vice president of the United States basically does not do much. I mean, they're like the spare, right? We have an heir and a spare. They're the spare. But sometimes they have to come into the Senate to break a tie. But that's it. All right. It's got pretty minimal here. Clause 5, the Senate shall choose their other officers and also a president pro tempore in the absence of the vice president, or when he shall exercise the office of president of the United States. So this piece is saying if the vice president has been bumped up to the president, then the Senate has protocols. In order for the vice president to be bumped up to president, he or she has to be qualified, has to be the right age, has to be from a different place than the president, has to not have served 2 terms. All right. So right here, we're saying the vice president has to meet the same qualifications as the president, or else he cannot be bumped up into the presidency. All right. I think that's very important. So there's a lot of questions going on about that. Questions answered, and there you have it. Next, clause 6, the Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, so look at this, we're in clause 6, and they're already like, all right, well, the president goes down. What do? The Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. 2/3 is a supermajority, is what we call that, all right? Neither are qualified. That's so funny. Oh, my goodness gracious. Yeah, true story, though. So here is the Senate's impeachment piece. Next, we have the judgment. So judgment in cases of impeachment shall not extend further than to remove from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So this is the part that was one of the biggest issues in the immunity case, because Mitch McConnell, Turtle Man, was like, dude, we should leave this up to the criminal courts. This should be in the criminal courts, right? And then it went into the criminal courts, and the people were like, no, this is political persecution. This is all about the political weaponizing of the justice system. But when they had the chance in impeachment, they didn't do it. They were 6 people short of convicting. 6 people short, and there would have been a conviction. So they claimed, let's take it to the courts, the criminal courts, and then in the criminal courts, they said, never mind, this should be an impeachment thing. All right, so you can see how it's kind of jacked up a little bit here. Yeah, the Turtle Man. All right, and so I will pause us here because we've just finished section 3 here. So of the beginning, and I'm just taking everybody through the Constitution here. I'm just walking you through it. All right, again, we'll start with the articles and then move into the amendments after that. All right. And what was the last thing I had here? Oh, yeah. So I just wanted to do a straight up Q&A at this point. Oh, you're welcome. You're welcome. So we've had several things happen over the last 48 hours. I was not on this weekend because, reasons. So let me just open the floor up here. We've got about 15 minutes left on my meter for Q&A if people have questions. Oh, I'm feeling so much better. Whoo, I'm feeling so much better. Thank goodness. I really am. And I'm very thankful for that. Yes, I saw that. Nancy, Pelosi, we adore her. We do, but she deserves to be able to go home, right? Yeah, she's leaving. Yeah. But she's earned it, right? I mean, to go home and be with her loved ones, and she put the time in. She's done her time. Yeah, I'm not sure I thought Mitch wasn't coming back either. I thought is what they said. Question about the SNAP case. Does that just go away if we reopen? No, it does not. SNAP case is out of control, everybody. That situation's out of control. Let me go grab my notes over here before my cat eats them. Nope, that's not that one. Here we go. It's over here. Okay. I've got two because I do need to go through the National Guard decision out of Oregon as well. So I've got updates on SNAP and then updates on the National Guard too. Here's the thing with the SNAP case though. We've got two SNAP cases going. We've got one, the Massachusetts case, where it is like 26 different states. They're like, dude, we don't. Let me back up. There was a memo, because of course there was a memo. There was a memo setting out these rules here that they wanted to have everybody follow. And here we go. And so 26 states were like, your memo sucks and we don't want to abide by it and stop threatening us. So they filed this lawsuit. That's the Massachusetts case, right? Here. So your memo's crap, rescind it. And then we have our, again, here, this is their lawsuit. And then we have the Rhode Island lawsuit. Rhode Island is actually a group of people. What am I looking at here? Was this I think this is the memo here. All right, here's the memo. Here's the rubbish memo that Massachusetts and friends were like, this is crap. So again, we've got, let's see here, regional directors, all agencies. So just so that you have some idea on the Massachusetts case, all right, FNS is working towards implementing the November 2025 full benefit issuances in compliance with the November 6th order from the District Court of Rhode Island. Later today, FNS will complete the process necessary to make funds available to support your subsequent transmittal of full issuance files to your EBT processor. We'll keep you up to date, blah, 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 blah. So they're going through this process of what you can actually do. Here's another piece here that was set out even earlier. They're working towards implementing the full benefit issuances in compliance with that order. So they're just saying, hey, give us a little time. And so Massachusetts is like, no, I don't think so, because your memo's rubbish. Rather than in the Rhode Island case, where we've got like 10 cities involved. So we've got Rhode Island State Council of Churches, nonprofits, international unions, alliances. Down here we've got a house. We have Martin Luther King Jr. Center, Community Action Program, and then we have all these cities, all right? And they're filed in a different jurisdiction. So this is the complaint that was taken to SCOTUS, all right? They're saying, you can't do this, you dumbasses, and so, knock this crap off. As opposed to the Massachusetts case, where they say specifically, your memo is crap, all right? So we got one crappy memo, all the states were after it, and then we've got the action itself, where we have the private entities and cities going after it. All right. I've been having a hard time distinguishing between the two cases, but alas, that's where we're at. So the thing that's going on right now is that Justice Jackson had said we're going to stay the lower courts. There's been an order, pay up, do some payments. And then they're like, well, we don't have any money. We're not going to be able to pay. But then half of the payments went through. And then there was this question of the court that's saying, well, let's wait. Let's hold on for a couple minutes because we feel like the Court of Appeals is going to come in here and take care of business, as Justice Jackson said. So then Mr. Orange was like calling people and was like, dude, we want our money back. Like, that's awful. That's awful. So if you received any money, any little bit of money that you were able to get because you were kind of first in line, he's like, give us back. We want it back again. Like, is he going to do, this upsets me so much. Is he going to do that for taxes, right? Is he going to do that? It's so weird. You're right. It is insane. If you got money, spend it. That's right. Or put it under your mattress or put it in a hole in the backyard, whatever. But you're like, this is my money now. Oh, something's wrong with him. We're all watching. I know. It's very cruel. It's very cruel. And, too, the other part of it is, I'm no doctor. I'm a doctor of jurisprudence, but I'm no science person, as all of you well know. I'm not science at all. But even I can be like, I'm not sure he's, what he's just saying, and I try to not bring in the first, administration that he had, because I'm like, things were really different. But I do think sometimes to myself, like, wow, he was kind of like, he was quick. He was quick on the comebacks. He was like running around doing stuff. And now it's like, whoa, it feels like the light's been pulled out. Right? You can lock the cards. Oh, no. Oh, that's awful. Okay, get everything you need all at once, everybody. No. Do what you think is best, everybody. But how crappy is it again that he went after him? So right now we're in this weird purgatory situation where we've got temporary restraining orders that have been granted. And then in the Rhode Island case, the if the defendants wish to go forward any further on this case, they need to file a brief to the Supreme Court today by 4:00 DC time. All right. They already had requirements this morning that needed to be done according to Justice Jackson. And so now they've got a few more. So there are things that have to be done actually today. And Justice Jackson is like, dude, we got to move. This is so important. So it's sounding like they are wanting to continue to go forward with the lawsuit, the defendants. The other little wrinkle here is the Senate vote from yesterday, right? So the Senate, I think I was describing the bills as shit sandwiches, but that's very vulgar. So I'm not going to do that. We're going to do something else. How about, I don't know, anchovies? Is that the same? So the Republicans presented this like really bad bill, and they like dangled some good stuff in front of it, right? So they're like, ooh, we'll rehire everybody we fired, and ooh, we'll give you your back pay. Like, they should have done that anyway, big jerks. I mean, they created their own situation. So all of these employees are supposed to be able to come back. You're going to get paid your back pay. And, we'll be up and running in the in the SNAP world, right? Cow patties, exactly. So we're going to give you everything we took away if you vote for the same piece of crap that we presented earlier. So a few Democrats were like, all right, enough to move it forward, right? Because that's not okay, but that's what they did. Man, Bernie was on fire today. Bernie was like, you aren't even human. I'm here for it. So then it has to pop back over then through the House. The whole process is still going on. So, but we've got this little breathing room at some point to have the government open again. Just because they voted the way they voted does not mean the government is opening. Like as soon as the vote's over, they're like, all right, let's open it back up again. Doesn't still quite work that way. There are several other steps that need to occur. This is the time to be calling your people and saying, do this, do that, or, whatever. But this is the time. And this, again, the reason I bring it up is because in the Rhode Island case, let's not call it Rhode Island because that's a state, and they're also in the other case. What should we call this? The private people, the cities case. I don't know. The community, the regular people, the regular people's case. It's the one that's going up, and you've got this like a restraining order in place. So we should have. Oh yeah, Fetterman was I'm like, dude. So we should have a brief by defendants in the next couple of hours. So once that brief comes out, what I will do is a full live going through both cases and just explaining the difference and explaining where we're at. But I want to wait until we get one more. Until we get their filings from today. We've already had 2 filings just within the last few hours, so I'm kind of waiting on that. But does one case look stronger than the other? No, they're both strong. They're both challenging here. They just have different, right at the very end of any case here. Let me show you what I'm talking about. Yeah. So at the very end, you put your counts in, right? So count 2, this is the city case. Suspension of SNAP benefits is a violation of the Administrative Procedure Act, contrary to law, right? Against the defendants. And then if we pull the Massachusetts case out, we don't want to get them mixed up because that's a mess, as we found out the hard way. Yeah, here we go. So let's look and see what count 1 is here. For theirs. So let's go back a little bit. Here we go. We've got the prayer. All right. I'm making sure it's in order here. I'm not a big fan of the Massachusetts filing. I mean, it's okay, but it could have been better. All right, so here we go. Look at this. Violation. Here's their count 2. Violation of the Administrative Procedure Act here. 7062A, arbitrary and capricious and abuse of discretion against defendants. So that's their language, right? And then we go back again to the cities. Suspension of SNAP benefits, violating the act here. So that's kind of, the distinction is between. We've got a violation of the APA here because it was arbitrary and capricious. And then we have suspension of benefits, which is contrary to the Administrative Procedure Act. They're essentially the same, everybody, I guess is what I'm saying. And you can't say it in a way that doesn't take 5 minutes. So I would say they're both good cases, honestly. Both of these cases are good cases, and they're just a little different nuanced. So, they should keep going down the road. I'm not sure if they can put them together, though, because of those nuances. Again, here they're saying you've taken our benefits. Here they're saying you wrote a memo to take benefits, and your memo's wrong. So that's kind of where we're at on the 2 cases there. But both cases are good to go. And again, we should see some more filings just today even. Oh, thanks, Boxer Mom. Oh, thanks so much. So, and this is so important. The SNAP situation is so incredibly important. I have to, though, remind one of the most important things going on right now, truly, is the Oregon case. Let me grab that one. Where'd you go, Oregon? Whew. So the Oregon case, right? This is the one. California has been added to Oregon for purposes of the case. This is the National Guard stuff. Like what? That's not right. You shouldn't be doing that kind of stuff. Here it is. There is a finding of fact and conclusions of law that was just a couple days ago, and I feel like it's gotten lost in the rhetoric because of so much crazy business going on. But we've got an order explaining to the administration, you can't be doing this with our National Guard. This isn't right. And his decision was like 100 and some odd pages, and it's incredibly well written. He goes through the history, goes through the intent, he goes through everything. So this is very, very important. This is on my top to live about list. So this one and the snap cases I'm prepping for the lives that I'll be doing over the next few days. Yeah, the orange throws stuff a lot. Yeah. That's not a lie. That's no lie for sure. It's a lot. It's a lot, everybody. And the thing is too, and I've said this before, it's a lot for them as well. It's a lot for them. Like, we have a finding of a violation of the posse comitatus statute, right? We've got huge ones. Now we've also got some human rights violations now of how they're treating people when they're bringing them in. I mean, the interesting thing, as a side quest, my mother always said the reason why people were so upset, one of the reasons people were so upset during the Vietnam era was because we could see what was happening, right? The journalists that went over and like the filming and stuff, like you could actually see every day what was going on, in this like world of television. And I just think to myself, like, we're in a similar situation here. We can see what's going on. Like, they're not just in the streets doing stuff under the cloak of darkness. Like, we're seeing it. You can't gaslight us out of it because, like, I just watched it. Like, no, that didn't happen, but I just watched it. And I think that's what's happening here with a lot of our National Guard situations. We have to be so careful. This is such a slippery slope, everybody. It is such a slippery slope. If it doesn't get firmed up, we're gonna be in some trouble. Yes, happy to help keep everybody informed. Does it go to the Supreme Court next? Well, in this one, not next. It's not gonna be next. I'm not even sure what the next move's gonna be on this. I'll have to pull it to see, because this is complicated, right? Careful of AI. Oh my goodness, true. It's getting murky on it's so true. Absolutely. I wish there could be, listen, somebody needs to do this. I'm going to give you a business idea and you go do it and I'll pay for it. No, that's not true. I won't pay for it. My husband will be mad at me, but we need to have some kind of a decoder. We need some decoder ring that says, like, if these elements are present, then what you're watching is AI. That would be very helpful for us old fuddy-duddies, Like, I was watching a show yesterday, and it was a flashback to a woman's childhood. So she was like, 10. And they had taken her face and AI'd it onto a 10-year-old. I just about fell out of my chair. I was like, how did they do that? What's this magic? What's this wizardry that they're doing? And then I was like, oh yeah, it's AI. And still freaking out about it. It took me a little time to be like, all right, let's do that. But there's AI all over the place. And if you're super old school like myself, it's like if it's not a cat singing or some kind of a cute baby throwing fruit, like, I don't know if it's true or not sometimes. Kinds of restrictions on, yeah, that's true. Good point. Seamless is hard to tell. Yeah, exactly. Right. I mean, that's what the point is. But right. I don't know. Again, it makes me nervous. It makes me nervous for sure. Oh my goodness. All right. So before I gotta go here, because I gotta go here in just a minute. My question would be, which do you think would be the best for the next live? So I'm hoping to do a live tonight. We'll see how I'm feeling. I do want to keep going through little pieces of the Constitution. But if you were to vote, and I don't know how to do that fancy stuff, but would you want to hear about the National Guard case, or you want updates on the SNAP case? Which one do you think is more important to you, that you're the most interested in hearing about? It's an interesting situation, Lex, and several people have said that the Dems that they needed would, in order to pass it, could be convinced to pull back, to change their vote. I thought that was interesting. Like, well, so call your people. If that Dem is one of your people, like, call the people and tell them, okay, National Guard, snap, snap, snap. Okay. And what I'm thinking about doing is snap, 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 snap. Okay. All right. All right. I think we're pretty evenly. Yes. Well, of course. I'm happy to keep you posted on that. The big thing for me is I'm really waiting to see what the filing from the government is, what it says. Because again, that's due here in like an hour. And if they're able to submit that and, come out okay on that, that will probably be the best one. Okay. It does look even. Well, maybe we could do 50-50. We could do. All right, we'll start with SNAP and then we'll finish with the National Guard, all right? They're already taking people. Now, a phrase I never thought I'd say is you need to be more specific. Which people where, whichever case had an update. Right, so again, friendly reminder, the Rhode Island State Council of Churches, so the church case, oh my gosh, thanks so much. The private person church case is the one that Justice Jackson's on. Page pulled up. If it's not there yet, but I'll draw. Okay. There you do. Oh, you're so sweet. Oh, I appreciate it. Yeah, we can't get too tangled up. We kind of like hit it and move forward. That's why I think if you have other legal creators, like if you combine us all together, you get a good idea of the full picture, I think. Running amok? No! Senate has till 2 a.m. to vote. Yeah, I mean, there's a lot of info out there on what's what and what's going on. So, of course. Oh, I'm happy to. I wish I could be a bit more specific on the times when I can come, but alas, I just do not know. I don't have that kind of knowledge on when exactly things will be working for me. So, unfortunately. So I may or may not be back on tonight. I'm going to try to be back on tonight, but we shall see what happens. All right. Okay. So did anyone, as we're working to get the poll here, did anyone have any other questions here before I close us down here? It's like oh, that's so sweet. It's like a gift. Oh, yes, Willie B. Of course. Oh, yeah, and I broke the light. Man, I tell you, I just don't even know my own strength anymore. I'm just like coning the light. Like that light didn't do anything wrong, but I'm like, you're done. Oh, thank you, Compy Bear. I hope so. Selson, thanks so much. 865. You are most welcome. You are very, very welcome. I'm happy to come on and help as best as I can. It's been a stressful few weeks here. Like, I'm eating like pumpkin pie, ramen. That's where we're at in the world. We're in a place where you can have ramen that's pumpkin pie flavored and you don't care anymore because it doesn't matter. Yes, call your senators. I mean, I know people have been, but this is like when you for sure call your senators. Like you can give them a little breathing room for a couple of days, but boom, what time? If I'm feeling good enough, I just don't even know. I know sometimes I can say, well, 6 or 7. I just don't know. I just don't know today. Really? Oh, that's good to know. Another attorney said 8 Dems that vote is not it for. Well, yeah, that would make sense if they're protected. Yeah, Fetterman doesn't care. I don't know what happened to that dude. He was like, yay, we can go and save the world, and walking around in his shorts and a sweatshirt. And then next it's like, dude, who even are you anymore? Yeah, he's gone through some kind of a transformation. I'm not impressed by your transformation, sir. Yes, put your notifications on. Hopefully you'll get it. Hopefully, I try to start a little bit later, but and for those of you, again, oh my gosh, everybody, for those of you who are able to send gifts, oh my gosh, I'm so thankful. I will be needing to get a new tripod and light since apparently I'm punching stuff again. So I do truly, truly appreciate it. The gifts and the support is absolutely what I put into for ink and paper and fun pens. So every penny goes back into this wonderful fun thing that I get to do here. So yes, the paper fund. So I appreciate it so much, but I don't want anyone to feel uncomfortable with that or feel pressured, because there's no pressure whatsoever. See if there's one in me. Yes, I do. Thanks, BC, so much. Yep, that's my Venmo. Yep, I'm hoping I should have enough sticky notes to get me through the next few weeks, but I tell you what, I'm going to need to order some. Really? You think it's from the Hangout? Of course, Lex, of course. It could be. It seems like he got in with the wrong crowd for some reason. I don't know exactly, but all right, let's take a look at the poll. You're welcome. All right, so here we go. Oh, we're supposed to start. I didn't start. Oopsie, I screwed it up again. I better go, everybody, before I start taking down some stuff that doesn't need to be taken down. Yes, Meme NATO. Okay, everybody, have a great rest of your day. Oh, thank you so much again, everyone, for the gifts and just for the support of coming by and asking questions. I really appreciate that. I will try very, very hard to be on again tonight, so hopefully I will see you all later. So thanks again for coming over for the Lunch and Learn.